A lot of people just put, oh, it's $500, so forth. You got to have more of a description. And another thing is they don't describe in detail what the product or services that they're selling. So you leave this product term out there. You have to define this. Okay, some of the other terms that go within the contracts, I always include a confidentiality clause in every contract that we sign. That's huge. We put that language in, and if someone discloses information and they weren't supposed to, I now have a confidentiality clause that I can go back to the client and say, look, you're giving away information that is vital to us, and please follow our guidelines as to how it should be disclosed in the manner. And if you don't, you're breaching this contract, and you're facing attorney's fees and all that. And I always try to go and negotiate. So whenever I get a heads up, I will call the head of a company, and I will always go in with a representative of one of my clients before we go in and file litigation and all that. And because you don't want to lose that client, a lot of times they just forget, or the employees aren't trained. But we always have a confidentiality clause in a lot of our agreements. So if something does happen, we're all set to go. Okay, we've already talked about venue, jurisdiction. And here's another thing is addendums and attachments. Whatever contract that you use, whether it's products, services, you should always include attachments or descriptions of that product. If you have blueprints or some kind of product printout of that, it's always good to include that, because then there's no question of what this contract was about. That's very important. Now, if you have employee contracts, other contracts, you want to leave open some addendums. One of them is, if you're manufacturing products, one of them could be pricing. So you will give a basic range of that price, but as we all know, technology changes, and also the price of product changes. So the manufacturing cost is always increasing. In some cases, it decreases, but instead of putting, you have a master contract, and then within that is a separate addendum that is a description of all these products and all that for that 1 year. Okay, so this master contract is for 5 or 10 years, but then you have an addendum that talks about all the services and product for that 1 year or a couple of years. Does that make sense? I'm getting a couple of nods, so I'll take that as a what else happens if you have a service or a product that is alleged to be a defect from the end consumer? A lot of people do not put this clause within their contracts. And there's another term of art called cure. We call it, it's known as a right to cure. C-U-R-E, sorry, I have Wisconsin accent. Wisconsin accent. It's the right to cure. So we put the terms in there that if this product has a couple of things wrong with it, you as the seller or manufacturer of that product say, hey, look, contact us before you go off in the deep end. Contact us, give us a chance to remedy the situation. And it's so important to put that in a contract. There's so many times when they're emotional, they go file a lawsuit, then I come into court, I contact the other attorney, and I say, before you do that, as a matter of the contract, you must give us proper notice and a chance to right the wrong or to cure that defect. And a lot of times that stays a lot of litigation. It gives you a chance to fix what was wrong. Does that make a lot of sense? A huge one. But I still see this that's not in contracts. Compliance with law and regulations. Now, everyone knows about HIPAA. Everyone knows a lot of the details, but there are also a lot of local manufacturing laws, and also federal, state, and local laws as well. So if you're dealing with someone coming into the state of Illinois or whatever state you're in, you may want to have them be compliant with some state laws that you have to be compliant with. And again, if you don't put that in writing, you can say, well, you never put us on notice. So that's huge. Just that alone can save a lot of headache, not on your end, and not on their end, as long as you put it in writing. Now, another thing within the healthcare industry are coding terms. This is so huge. Everything, whenever you speak to a doctor, a lot of the products that are in the manufacturing industry are the coding that goes along with it, and the medical coding. So again, part of what you want to do is use industry terms, common industry terms that are aligned with that service or product. Okay, so when I speak to an accountant and there's certain terms of art I'm going to talk to, when I'm going to use talking to an accountant, when I'm talking to a physician, I use a whole new term of art with them. Sir, if you want to come in, grab a seat, come on in, okay. So that's another important term that you want to put in the contract. Okay, another huge one. Penalties for default. Penalties for default. I see a lot of contracts, but they don't spell out what are the legal remedies in the contract. Everyone always assumes, I'm going to go file a lawsuit. That may not be necessary. You may have some other remedies. One of them could be arbitration. This is very important. A lot of companies will use either binding, this is very important, you're going to write this down, non-binding or binding arbitration. Basically, you're going to take your case before a set of regulators or people within your industry, known experts, and you're going to go within that state and you're going to arbitrate your dispute without going to court. Here's an aspect, when you file a lawsuit, if it's above $50,000, you're looking at 2 to 4 years minimum to litigate. It's a very slow moving process. So one of the ways that we get around that is we have an arbitration clause. And it's a great way to put your case before some industries, and then it's not the lawyers threatening all the parties, it's usually legal or industry experts that will tell you about the case and what they believe, what the breach was and what the damages are. So it's not coming from the biased attorneys. That's huge. And even if you settle, let's say 50% of the legal issues that are out there, and let's say, yes, we breached, and now you're just arguing about damages. So you may just go to trial just on damages. So you just saved yourself a year, 2 years of litigation and costs with it. That's huge. Okay, so you want to list all your penalties in all these contracts. People are non-compliant. There's other terms of art when you deal with an attorney. If an attorney ever tells you, look, it's boilerplate terms, it means that they're just basic terms in every contract. But I want to emphasize here today that you have to be familiar with all of your contracts. Don't assume that what the lawyer puts on that paper is what you wanted. You have to go through every term of that contract, know it and understand it, and get close with your lawyer and your legal team. And if you don't understand it, don't breeze over it. Have them explain it to you and go through these contracts.